Good afternoon. Tom Leonard, Technology Policy Institute, and we are delighted to be co-hosting this event with Christopher Yu here and the Center for Technology, Innovation and Competition at the University of Pennsylvania Law School. The presentations we're going to hear today represent the output of a project that CTIC and TPI started almost 2 years ago, right after the 2015 Open Internet Order had been adopted. And the purpose was to get a group of very smart people with deep knowledge of the communications and IT sectors together to write papers on the general topic of the future of the internet ecosystem in a post-open internet order world. Little did we know at that time that the world would change significantly in a relatively short period of time. But luckily the papers are just as appropriate today, and perhaps even more so, for evaluating the potential effects of rescinding all or parts of the open internet order, which, as you all know, the FCC is now considering in its current proceeding. So we've titled this event, "The Future of the Internet in a Post-Internet Regulation World." I've got to say that the quality of the papers written for this project is really exceedingly high. I think they exceed our expectations, which already were very high. Both the ones by the authors represented here today, as well as several others that were part of the project and are of equally high quality. We hope and expect that these papers are going to become valuable references for both scholars and policymakers as this issue is debated now and in the future, because, as we know, unfortunately, issues like this are rarely permanently resolved. All the papers are going to be published in a special issue of the Review of Industrial Organization, edited by my good friend Larry White. So I'd like to invite Larry up here to say a few words.
All right, let me see if I can first get. There we go. All right. So I'm Larry White. I'm the general editor of the Review of Industrial Organization. There is the contents, the cover, and in fact, just to make sure, in case your memory is not photographic, I've got hard copies of all that cover. So there it is. Please, I don't need this. I was a cheerleader. Oh, you're recording it? All right. I was a cheerleader in high school. So let me just expand. First, let me emphasize what Tom just said. I am really pleased that this special issue has come to hard copy life. As Tom said, these are really a good bunch of essays, not only from the authors you see before you, but the other men and women who are part of the special issue. And let me just give appropriate credit where credit is due by giving you a little bit of the historical background on what happened here. As Tom said, the origins go back maybe even a little more than 2 years. It was David Sappington, an economist at the University of Florida, who suggested to me that, net neutrality is an important issue. It's not going away anytime soon. It would be a worthy topic for a special issue of the Review of Industrial Organization. And of course, I immediately said to David, so how would you like to find the authors and shepherd that? Oh, not so fast, David said, but he suggested Chris Yu. And so Chris did indeed step up. And then a few months later, my friend Tom Leonard sends me an email, had the review ever thought of doing a special issue on net neutrality? And I say to Tom, well, gee, it just so happens, why don't you talk with Chris? And so they collaborated, and then Scott, where are you? There you are. Scott, then took over the shepherding at an important point, and as you can see, wrote the introduction. And so it's really been a collaborative effort. I'm really pleased. You've got the contents. You could always contact, it's of course published by Springer, and if you wanted, it's available online. If you wanted the hard copy, I'm sure Springer could somehow find the means to get you a hard copy as well. So again, welcome, and I'm looking forward to hearing what all of the speakers are going to be saying today. Thank you, Tom.
Thanks, Larry. So we are going to go actually in alphabetical order, and I've asked each of the speakers to speak for no more than 8 to 10 minutes, and then I think we'll have time for Q&A and a good discussion. I'm going to start with all the bios are in your handout, but going to start with Michelle Connolly, who is a professor in the economics department at Duke and a former chief economist at the FCC.
I'll try to use this. All right, so I had expected to be towards the end of this, but when I heard this was in alphabetical order, I decided to add some things to my presentation to at least give a starting point to these discussions. And as part of that, so this is not in my paper, but last week I was at a broadband competition thing, and I thought that this would be, looking at the most recent data on the broadband market might be a good place to start while discussing these things. So a couple weeks ago, I pulled up all of the Form 77 data from the FCC, and there are a couple takeaways. One is that the amount of access and competition in the broadband market is far greater than the tone of the 2016 FCC broadband report. And part of that is because they intentionally chose to focus on terrestrial broadband and services that offered minimum speeds, lowest speeds of 25 megabits per second download, 3 megabits per second upload. So here they were looking at 2014 data, and if you look at percent of census blocks with housing units, in terms of access, if we look at the min of 10 megabits per second download and 1 megabits per second upload, 100% of census blocks in the United States have at least one provider. If we use what they were using in 2016, even there, we have 79%, 96% of urban and 61% of rural. And remember that in the United States, 82% of our population is urban. In terms of competition, if we are again looking at the 10 megabits per second criteria or threshold, 97% of census blocks have more than one broadband provider. And at the 25 megabits per second, 42% have more than one broadband provider. I want to point out something that is a little dated, but Connolly and or Jim Prieger and I, while we were at the FCC, were granted access to the forms from the Form 77 data. And in so doing, we were able to link providers over time, which you can't normally do. Normally, you can simply see the number of providers. And so when we're looking at turnover in the market, we can only look at net changes. But when you actually can link the firms, what we found is there was actually a tremendous amount of turnover within markets that was not observable in the normal way that we looked at things by just looking at the net number of broadband providers. So this is also suggesting much more competition than was kind of thought of as existing before. Here's the real reason I did the broadband download, the PowerPoint. So I don't know how much you're going to learn from this, but I thought it was pretty. And it's all form over substance. So what this graph shows you, so there's this website called Ookla, and they actually do, if you're having slow internet, you can do this broadband test speed. And so they pull all the data from this. And we got the data from 2008 to 2015. So these are actual observations of speeds that are being registered from different households in different markets. And the distribution is for the entire set of markets in the United States, at least for which Ookla have data for. And they have data for a lot. What's particularly interesting is if you look at 2008, which is kind of this dark distribution, becomes hidden towards the back, you can see the peak before was probably about 5 megabits per second. So this is 2014, 2013, the peak would be under 20,000. And with this 25,000 minimum that the FCC was suggesting, you're really cutting out a huge amount of the market. And clearly people are able to get to Ookla to do this speed test, so they're able to use the internet. So that's one point that I wanted to make with this graph. And then obviously the second one is that this distribution was very tight here in 2008, but now we've had huge increases in the speeds in certain markets. So the distribution is becoming larger, but the mean's moving up quite a bit. And what's interesting is that prices haven't been going up as quickly as the speeds have been going up. Now, my paper, I came late to this topic of net neutrality, and I had wanted to write something that was from a slightly different perspective from the existing papers. So I decided to look at the issue of the digital divide, and particularly how net neutrality regulations might impact the digital divide. So the first thing we looked at was the Pew survey, and they surveyed consumers and their broadband usage, and they asked the households that did not have broadband in their household why they did not have broadband. And the responses were kind of interesting. Only 7% said accessibility. 19% said price. 34% said lack of relevance of the content. And 32% said digital literacy. I found this amazing because we tend to be talking always about access and then secondarily price. But clearly we're missing a big part of the story here. Also from the Pew surveys, we could see that of those who are least likely to use the internet, there's certain groups. Anyone over the age, or people over the age of 65, in their 2016 survey, 41% of that population were not using the internet. Those without a high school degree, that's 34%. Earning less than $30,000 per year, 23%. And then rural, 22%. But one thing to notice is, of course, the rural population is on average older, less educated, poorer. So a lot of what we're seeing in the rural areas are having to do with these aspects, not just the amount of access. And so access is not the single most important thing that we should be focusing on when we're looking at the digital divide. All right, so how does this relate to Title II? Well, with the Open Internet Order of 2015, here I'm just going to do a couple highlights because the other speakers will do a much more complete job on this. But this regulation was justified on the grounds of supposed last mile monopoly power. Now, I just want to point out that despite saying this, they applied Title II regulation to both mobile and fixed broadband, even though they're kind of ignoring a lot of things going on in mobile. And we know that mobile is highly competitive. And this is also despite the fact that using the FCC's own data, 97% of census blocks had 2 or more broadband providers offering at least 10 megabits per second. I'm going to focus on the aspect of the Title II regulation that blocks paid prioritization or any kind of fees of internet service providers to charge to content and service providers. This is even true if they're causing some kind of congestion or negative externality in the network. And it's even true if the content service provider would find it profitable to pay for priority access. So some content service providers currently pay for content delivery services to allow their content to reach the consumer more quickly. So we see by their behavior that they find that profitable. But in this regulation, that was not allowed. So what does this do to the digital divide? Well, anytime you start affecting parts of the market, and in particular start reducing profits for the internet service providers, then there are going to be some consequences. So we knew theoretically this would reduce investment. There have already been 2 studies that have looked at broadband capital expenditures and have seen really pretty significant declines from 2014 to 2000. Okay, I'm a little dyslexic. 2016. And what's impressive is this is not just a drop in the rate of growth of investment. It's an actual drop in the level. With that, you get reduced deployment. Well, with reduced deployment, you have reduced entry and competition. You also have reduced quality because of decreased capacity and increased congestion and less innovation. And in terms of the digital divide, well, this is much more likely to be happening at the most marginal markets, which are exactly the ones that we're worried about not having a lot of take up in broadband. Second effect is what we call the waterbed effect. And here the idea is that the Title II regulation essentially forced the internet service providers to provide a subsidy to certain content service providers. But then this gets passed on to the other side of the market, the consumer. So that leads to increased pricing, which is especially harmful for lower income households as a percentage of their income. But a lot of this price is because congestion being created by what I call high-end users. So if you're a low-end user and your price is going up because of the behaviors of someone who has a subscription to Netflix, but that congestion pricing is going to everyone, then they are paying a burden for something they are not creating. And certainly if we're talking about low-income households, that means that at the margins, there are going to be some households who choose not to have broadband because the price is too high. So this, if anything, would exacerbate the digital divide, not help reduce it. And similarly, you can squeeze things by increasing price or decreasing quantity. Decreasing quality, so lower quality of service. But another thing is offering data caps, right? So that people who are causing a lot of congestion hit these data caps, and that's a form of higher prices for the consumer, and people are starting to complain about that. The last one is much more of a kind of economic theory thing. Some proponents of net neutrality were saying that this would help produce more content, and that necessarily would have to be better for consumers. But that was assuming a lot of things in terms of consumer preferences and in terms of the types of content and service providers. The reality is we have different types of consumers in the world, and the reality is we have different types of content and service providers. So the value to consumers doesn't increase linearly with volume. And a point that I want to make, if you look at market structure, these things actually can depend very strongly on economies of scale. So if you have a government policy which forces or encourages artificially high entry of new entrants into the content and service providers, you can actually be lowering average quality and diversity of content. So this gets into some technical things, but I just want to bring this up because that's one of the big arguments that proponents of net neutrality had put forward. So back to the future, where the FCC is now talking about moving back to Title I, classifying this as an information service. which should have some pretty strong effects. It should primarily reduce the regulatory uncertainty that had been caused mainly by the ease with which the FCC could start putting its little fingers in every little dimension of broadband. It will remove the existing distortions that were introduced in the Open Internet Order. Should allow for a rebound of broadband investment in deployment and innovation. Should lower prices, improve quality for consumers. And most importantly, from the perspective of the digital divide, will stop kind of working as a force against the natural market forces trying to reduce the digital divide.
Our next speaker is Bob Crandall, who's I'm pleased to say an adjunct senior fellow with us here at TPI, as well as a non-resident senior fellow at Brookings, and for many years a prolific writer on telecom issues.
Thanks, Tom. Pleasure to be here. I do not have any slides. Initially, we weren't going to do slides, and then we were, but I was traveling, and besides, if I knew anything about the future of the internet, I wasn't going to share it with you for nothing. Maybe my colleagues here will, because they're wealthier than I am. But yeah, Tom and Larry talked about this conference we had last fall. Actually, I was not physically present at the conference, and the papers that were published in the Review of Industrial Organization. My paper, which I'm going to talk about, and I'm going to provide some additional results, dealt with who wins and who loses from all this. And I used a rather traditional approach in economics and finance, that is to look at events along the way that were unanticipated by the market and see how the individual equities of players in this space responded. And I looked at 4 different events leading up to the February 15 decision, March 15 publication of the final rules. And they were the DC Circuit opinion of January 14, 2014, invalidating the open internet rules. The Netflix Comcast paid prioritization announcement. President Obama's rather overt wading into this space and recommending Title II regulation. And then finally, the publication of the actual rules, because the FCC announced its decision, but didn't publish the rules for a couple of weeks thereafter, and they might have contained some surprises. Now, some of you in this room, you all probably are in this space, have views as to whether the DC Circuit opinion in January 14 was anticipated or unanticipated. I think most would agree, and I think maybe the lawyers here would agree, that the obiter dictum in the decision was probably not anticipated, right? That the rules were invalid, but there were ways for the FCC to do this, and the court showed them how to do it. So that was the unanticipated part of it, perhaps. The publication of the FCC's final decision is obviously pretty much of a non-event, but the 2 in the middle, the Netflix-Comcast agreement and President Obama's wading into this, clearly were unanticipated. And so therefore, looking at how stocks performed, what their excess returns were in a 3-5-day window around that period, or even immediate response, might provide us some idea about why this was of interest to the companies, what the likely effect on them would be. Unfortunately, the results show very, very minor effects in most cases. For instance, the excess return to Netflix around any of these events is not statistically significant. They never respond. Now, maybe that's why Netflix sort of backed off its lobbying on this issue. I don't know. The media, none of the media companies systematically responded to any of the particular those 2 middle events, the Netflix Comcast agreement and the Obama net recommendation. The firms that were affected, and generally negatively affected, were AT&T and Verizon around the Netflix Comcast announcement. Namely, I guess their stockholders were concerned they would be taking more money through paid prioritization, and this would be bad for them. I don't know. Or the alternative explanation, obviously, is this paved the way for moving towards more formal regulation of net neutrality. But the most interesting result was around the Obama announcement. There was very little movement except for 3 cable stocks. Now at this time, remember that Comcast, Time Warner, Cablevision, and Charter were independent of one another. But at the time, Comcast was in the process of trying to acquire Time Warner Cable and spinning off some of those cable systems to Charter. Cablevision was outside that whole merger operation at that time. And in fact, it was the 3 who were involved in that merger who responded negatively, and rather sharply negatively. Their stocks responded negatively to the Obama announcement. Cablevision wasn't affected. And for that reason, I conclude that what the Obama announcement did was to signal that there's no way the Obama administration is going to approve that merger. And of course, it wasn't long after that it was they withdrew the merger because they couldn't get approval. And interestingly enough, of course, then there was almost as big a merger with Charter and Time Warner Cable, even within the time period of the Obama administration. My results suggest that all along the way, the stock market didn't view net neutrality regulation as a very big deal, at least for the established players, the large media, traditional media companies, Disney, Viacom, CBS, Sony, and all those, or the new digital media companies, large and medium size, Amazon, Facebook, and Google, and the rest of them. But of course, I couldn't do an analysis of what the prospective effect would be on the very small entrants into this space, nor could I do any analysis on the nascent entrants. I mean, there's simply no stocks trading among those companies. So my results don't bear on that. Yet if net neutrality was likely to allow more competition in that space, you would have thought it would have had a negative effect on the established players. And in fact, it did not. So I'm still puzzled by why I read in the paper, I'm not very close to it these days, that some of the large digital companies in Silicon Valley, digital media company, are still in favor of continuing net neutrality and opposed to repeal. One possibility in all of this, I think one of the litigants in the appeal of the Title II decision by the FCC is a small media company who argues that he needs paid prioritization in order to succeed. And without it, he can't compete. That he's not big enough to establish his own network facilities and hook up that way, that he has to pay for better quality access because of the type of service he's offering. Now, finally, I just want to suggest that, unfortunately, Larry put this thing to bed before the biggest event in all this space, which is, of course, Donald Trump's election. And that's an event analysis I think you'd like to look at. So immediately, sometime afterwards, I decided let's go back and look at what the effect in this space and other spaces of the Trump election was. We've heard a lot about how there was a Trump stock market rally and all that sort of offhanded stuff. I'm talking about the immediate reaction of the stock market after the night of November 8th to the election of Donald Trump. Who went up, who went down, and some of the results I have, and I can share them with you. I can send them to you by email if you'd like. Are not surprising. Who are the biggest winners? The steel companies, of course. I mean, trade protection was going to return with a vengeance. So steel companies, machinery companies, automobile companies, they did very well. Defense, and given what's going on now, you can see why. And the large banks. Okay? Energy was sort of a wash. But in our space, the space we're talking about here today, the ISP media space, the effects were fairly large excess returns for the cable companies, more modest ones and mixed ones for telecom companies, and large negative effect for Silicon Valley companies. Now that I don't think that bears directly upon Title II. It may have something to do. Title II may have something to do with it, but I think what it suggests is that there was going to be a change in atmosphere at the White House, and that the Obama administration's tilt towards Silicon Valley was clearly about to be reversed. At least the stock market thought so on the night of November 8th. So.
Our next speaker is Michael Katz, who's professor at the University of California at Berkeley, and also a former chief economist at the FCC and also a former chief economist at the Antitrust Division.
Thank you. It's a pleasure to be here. I thought I'd talk about today is the rule against paid priority. One of the reasons for focusing on that is I think this is not a coincidence, unfortunately. I think it's one of the most misguided of the bright line rules, and it's probably one of the most widely supported. So let me talk about, in particular, I want to talk about one argument that's made against paid priority, and that is that it would unlevel the playing field. And as I say, I've heard Republicans or otherwise are quite conservative who still buy into this, and certainly lots of Democrats as well. The thing is, the question you have to ask is, what's so good about a level playing field? Right? When what we're talking about really is not about, what we mean by leveling the playing field is blocking competition. I mean, suppose there was a cartel that got together and said, you know what, we need to level the playing field. We can't have some firms offering better quality products than other firms. That's just going to lead to problems. It's not fair to the firms that don't want to offer high quality products. We need to level the playing field. So let's have a cartel that bans quality competition. Well, as it should be, that's illegal for them to try to do it. Yet that's essentially what the policy is doing. And in fact, I was thinking about this, and I was thought what I might do to make the point is propose here today that we have something called advertising neutrality. Because if you think about it, it actually makes just as much sense as net neutrality. After all, to use some of the other net neutrality arguments, people are already paying for magazines and cable networks anyway, so why should these companies be allowed to double dip and charge for advertising? So all advertising should have to be free. And not only that, all companies should do the same advertising. Because if you let some people advertise more than others and spend money on advertising, it's not fair to the little startups that can't afford to advertise. The problem is I'm not going to make that argument because I was going to do it as a joke, but I realized it might actually have the opposite effect and start a new movement among some people, particularly when you started throwing in the importance of commercial free speech. So you could really get, okay, you could get all of the net neutrality arguments there. So first off then, I think it's really been an abuse of the term, I'm talking about leveling the playing field, because there are times when it makes sense where what we mean is we're against non-neutral regulations that artificially favor some firms over others. That's very different than saying what we want to do is we want to block competition because we don't want some firms to get ahead. Other people say, all right, well, maybe generally competition's good, but I'm taking too short-run a view of things, and really we need to also have a dynamic view and think about what are the effects on entry. Well, here, the answer is it's ambiguous, and we just heard about, Bob was mentioning one example, but there are at least two ways in which having paid priority can help entrants. So one is that it can allow an entrant to differentiate itself. And my paper has some formal models which are really just examples. I mean, they're well established in the economics literature generally, but it can help an entrant to come in if it can purchase, say, a unique level of priority, or if it's willing to purchase higher priority, say, than its rivals. It may be a way for them to create a niche to differentiate themselves and be able to crack the market. The other thing that can happen is the entrant may have a product that they weren't trying to need higher speeds, but it turns out that whatever their business strategy is and their product strategy requires higher speeds to really work well. And so again, having the opportunity to do that, to pay for priority, can actually facilitate entry. Now that said, there are other examples where you might have the incumbent is the one that values the speed, and so it could have the opposite effect. It could make entry more difficult. But all of that's just to say that what it's going to do if we start doing it, we're going to distort competition, and there's no reason to think that it's distorting it in a particularly good way. And by the way, on that last point, if you think, well, wait a minute, maybe it tends to favor incumbents if we have higher speeds, then the FCC should stop trying to promote higher speed internet. They should say, oh, that's no good, because that's just helping people who know how to use higher speeds. We need to slow down the internet to let people like Mike Katz have a chance with their really bad applications. So, as I say, I think this whole leveling the playing field, if you think about it, really is, while it claims to be about competition, it really is an anti-competitive policy, which is why I sometimes say it's the Robinson-Patman Act for the 21st century. Is the goal of the Robinson-Patman Act ostensibly was to promote competition, but what it was really about was trying to stop the rise of large, efficient retailers and to preserve the profits of smaller ones. Now, So let's talk about it. So if that's saying, well, okay, it's bad, it's stopping competition. Are there other problems? Well, yeah, as Michelle mentioned, right, there's value to variety. Okay, while it may be true that a bit is a bit, it's certainly not true that a bit stream is a bit stream. Right, different applications and different bit streams have different requirements they need to actually create value for customers. Right, as people know, it's very different if you're talking about email versus you're talking about telepresence in terms of what kind of quality you need to have from the network in order for it to be a high value service. So there in fact are good reasons to treat different traffic streams differently. And in fact, that's long been recognized. It was built into the internet as far back as I could trace in 1998. The internet protocol v6 had built into it mechanisms to give certain traffic flows special treatment. David Clark, who's one of the fathers of the internet, talked about when the original NSFNet, before it became commercial, in fact, had prioritization in it, prioritized interactive streams. So in fact, there's value to variety. The internet has long been set up to try to deal with that fact. And moreover, we see other market responses, right, which people have talked about, things like CDNs, or large content providers or edge providers putting in their own networks. And we see companies arranging to have deeper and deeper connections into bias networks, right, to run their network facilities farther into the bias network in order to improve the quality of the connections they have with end users. So we see people buying priority in other ways already. So now some people come back and say, well, wait a minute, that's okay. We're not really against all competition, but that's different. If we let the bias provider offer these different levels, we're worried about that because we think that bias providers have a lot of market power. Well, let me stay away from the issue of whether they do or not and just say, let's suppose they do, just for the purpose of this argument. Okay, so bias provider has monopoly power. Well, so what? Whether or not they offer paid prioritization is not going to change that fact. Say, but maybe they'll abuse their monopoly power, they'll engage in price discrimination, they're going to use these different levels of quality, different levels of priority as a sorting device in the form of price discrimination. Well, that could well be, but what the economics of price discrimination tells us is hard-pressed to know whether that's a good thing or a bad thing. As a general matter, it could be either. Now, that doesn't mean we should just say, okay, fine, let's do, let whatever happen, happen. But it does suggest that having these broad prophylactic rules that just ban something are the wrong way to go, right? That the right way is to look at things case by case, which is what the antitrust laws, in fact, are set up to do. And indeed, actually, I'm going to come back, ask the Robinson-Patman Act again, but at least implemented correctly could actually have some benefit here, because it is ostensibly about price discrimination. But it says to look at things case by case, not through these wholesale regulations. Now you could say, okay, well maybe the FCC should do that, okay, case by case. But there I would argue again that we're better off turning to antitrust law because of the lack of precedent at the FCC. And in the case, if we look at applying general antitrust laws, there's a lot more precedent that can be drawn on. It therefore provides a lot more certainty or ability to predict outcomes. And as we've seen with the FCC in the time that it did have or has had the net neutrality rules in place, there's been a lot of uncertainty about what they actually mean in practice. Okay, now the last thing I'll say, in addition to having just point out, it's actually hard to stop somebody from paying priority because there are all these other ways to do it other than going to the bias provider. I also want to point out that trying to do it in a lot of ways then is antithetical to consumer choice. And if the market develops certain ways, if you're going to want to stop paid priority, you're going to have to stop a lot of other things with it. And in particular, think about the following. I think even Chairman Wheeler said, or at least the order said, and maybe hadn't meant it or didn't, but that it would be okay if consumers were to pick different speeds for different applications. I do want to emphasize the value of consumer choice, the importance of consumer sovereignty. So let's suppose that, in fact, you can do that. The world emerges where you can go to your bias provider and say, okay, tonight at 9 o'clock, I want to buy higher speed service because I want to watch basketball in 4K or something, but normally I don't want to pay for that, but I do now. Okay? So suppose we get to this world where consumers really have a lot of choices, a lot of flexibility. You can pick what speed you want, maybe other things. I don't know if any consumer will get the point that I want reduced jitter for the next hour, but perhaps that'll happen. Okay? Well, what would that mean? Think about that from the perspective of paid prioritization. In that world, what would stop a provider from saying, an edge provider saying, look, we want you to watch our programming, at the highest speed possible, so we will actually reduce our price, because we can tell what speed you're using, right? The applications have the ability to do that. We'll reduce the price if you buy a higher speed. So in a sense, we'll pay your bill for you. Okay, well, if they do that, that's paid priority. They're the ones who are buying the priority. Now you say, well, wait a minute, we won't let them do that. Okay, but then they could implicitly do it, because what do you do if one of these big service providers says, well, the edge provider says, we'll just charge lower prices, and since we know people value watching our stuff at higher speeds, when we charge lower prices, they can think of themselves as using that money, right? We don't have to have the explicit link, there'll be this implicit one. They can use that money in order to purchase the higher speed. So where the logic of net neutrality gets you then is I think we need to make it illegal for edge providers to start offering discounts, right? And well, not just discounts, they shouldn't be allowed to offer low prices. Because again, if you think about it, offering low prices is unfair to the little guy who needs to make a lot of money and can't afford to offer low prices. So let me end by saying that last remark was facetious, and please don't put that in either. The part that was not facetious is that is where at least some of the logic of net neutrality ultimately takes one. And I think that suggests there's a problem with the logic. Thank you.
Thank you, Michael. Next up is Josh Wright. Josh is a professor at the Scalia Law School at George Mason and a former member of the Federal Trade Commission.
I did have the benefit of watching a couple of attempts. Should I take that? So I can almost hear Tom Hazlett in my head. Those of you who know Tom, you'll know that's a loud voice. The work is co-authored with Tom, who is nowhere within 10 miles, or else you would know it. But the project that Tom and I worked on, and I probably will end up spending only a little bit of time talking about it, was really aimed at a empirically minded cost-benefit test of what was in the 2015 OIO. And I'll talk a little bit because I want to talk about the paper a little bit and plug it and make Tom happy too. But I think all of the discussion is really with a mind toward what would a cost-benefit test with respect to the 2017 NPRM look like? Would it pass? To me, that question is going to land right, I think, where Michael left off on the relative advantages and disadvantages of an antitrust approach versus categorical prohibitions or sort of more bright line rules. Comparative advantage dictates, I'm an economist and a lawyer, I was an FTC commissioner. Comparative advantage dictates that when in a room of this many economists, talk about the law all I can. And when in a room of people who know a lot more about the FCC than I do, talk about the FTC all I can. So I'm gonna land there. But to give a sort of a quick view, I won't talk about all of it here, but a quick view of what Tom and I do in the paper is we sort of go through the 2015 OIO and say, if one were to tease out empirical claims about the costs and benefits of the net neutrality position promulgated in that particular order, what would they look like? The cost side is easy. The FCC says the cost of this move are zero. Just not going to touch that. And the benefit side, they say, well, here's a bunch of benefits, right? And what the paper does is try to do some analysis and look at whether the empirical evidence ultimately supports or rejects the underlying assertion. Michelle already mentioned one of the big places where this debate has happened, or at least the battlefront upon which this policy debate has been happening with respect to The 2017 RPM is sort of here, NPRM. The 2017 NPRM with respect to CapEx expenditures or however we're going to measure investment. And there are some pretty serious attempts to try to measure those effects, both finding sort of declines of different dimensions. The FCC says something, and I'm at least going to show a picture because I have one, with respect to what happened following the 2010 OIO. And so we'll talk about that one in a little bit of detail in a second. The second empirical claim in the 2015 OIO that I want to talk about, because I think it sheds quite a bit of light on the answer to Michael's question, and I think the one I'm trying to address as well, is what are the benefits of moving to, I'm going to say, an antitrust approach for shorthand. My FTC colleagues are sort of in my ear as I speak now, saying a shift to the FTC is more than a shift to the antitrust laws. They have consumer protection authority, both in terms of deception and unfairness, and so we can probably, I'll find a way or be forced to get into that in Q&A, but if you hear me say antitrust approach, please substitute on your own FTC, antitrust, and consumer protection, which is clunkier and takes longer, okay? So fun bit here, in the 2010 OIO, focused on exactly these paid prioritization, vertical foreclosure type concerns. What's going to happen is you're going to have what the economists like to call vertical restraints, deals between biased providers and folks at the edge to come up with different business models, different speeds, any sort of differentiation you can think of, sort of encompassed in that type of agreement. And the 2010 OIO says, yeah, that's the bad stuff. That's the, if you're looking for a benefit of our rule, we'll cut that stuff out. Those of you critics of the 2010 OIO, we hear you saying those are just speculative concerns. We've got empirical literature. We will cite Austin Goolsby's paper. Good paper, it's fine. Nothing wrong with it, and this is not picking on Austin, who says, don't use this thing for policy, right? Measuring vertical foreclosure is a tough thing. It's hard to find identification and causal inference and all of that stuff, so please don't. I guess they did. And they say the Goolsby study is the one. Like, this is evidence that cable providers, anyway, is sort of close, I guess, have done some anti-competitive stuff. So I encourage you to find the paper and read it. Get over it's cable, not, it's fine, a bit. And here's what they find, and Tom and I discussed this in another paper. There's vertical discrimination going on, but they find that on average it is against the cable provider's own services. This is not sort of the thing that the net neutrality proponents were scared of. It's the effect going the other way. And they also find in the paper that the result of this discrimination along the lines and for the reasons Michael discussed was consumer welfare going up, not down. If you have to hang your hat on a paper to say I'm saving the world from anti-competitive stuff, this isn't your paper, and it's not what it finds. To the extent it finds something, it finds the opposite. I would love to think what happened was Tom and I wrote a paper saying the things I just told you, and that, speaking of causal inference, it got the paper removed from the 2015, but I don't think anybody reads my stuff other than maybe my mom. But they did remove it, so this is sort of the lost claim missing from my four, was we're going to save the world from anti-competitive foreclosure. See Goolsby, who found it somewhere else. And that's sort of gone. One point, and this is related to where Michael was going and talking about the standard economic literature on, I'll sort of shift more broadly from paid prioritization and talk about vertical restraints. There exist these vertical contracts in all sorts of industries, from cable to broadband to the FTC had vertical restraint cases in pipe fittings and software and hardware and manufacturing and retail, shelf space arrangements, all of this stuff. These are incredibly common. Okay? So for manufacturer and distributor to contract this way, to have some sort of differentiated distribution. Maybe it's speed, maybe it's quality, maybe it's the eye-level shelf space. So there's a big literature out there on this stuff. Really big literature out there on this stuff. The last time I counted, which was last night, the number of papers that make it into I think what probably is the best literature review by economists out there on this stuff is 47. There are numbers bigger than that, but that's not no evidence, right? And the overwhelming conclusion is something along the lines of this stuff is not only generally pro-competitive, it's really hard to find anti-competitive examples. They exist. This is not an impossibility sort of claim. They exist. They're really hard to find examples where vertical restraints are successfully employed with the result of reducing output, increasing the price, raising barriers to entry, creating monopoly power that would not exist but for the vertical restraint. Has happened, okay? But pretty hard to find, which I think is going to end up being an important point if we're interested in this question about what a ban on vertical contracts would look like and how an economist might think about its likely effects. I'm going to do the broadband thing really quickly because I think the most interesting evidence on this now, Michelle already pointed to, in terms of Halsinger's got a paper, there's another paper trying to estimate effects sort of more recently. But really quickly, what passed for the empirical evidence in the 2015 OIO was we had this claim, you know what, when we've got Title II, there's going to be a big boom in investment. They cite to some nominal figures. This is really easy. This is sort of fish in a barrel. If you control for anything, the trend goes away. The paper will do it for you. But if you control for anything, the claim that in this sort of 2010 or 2011 to 13 period you had a big investment boom, it goes away. Control for whatever you want. Number of wins by the LA Lakers in that season. Control whatever you want. The effect goes away. Anything correlated with economic growth, that effect goes away. Again, doesn't answer the question about the 2017 NPRM, and we can talk about that separately. But this is sort of the type of thing we do in the paper, which is sort of walk through these claims, take the best look at the empirical evidence that exists that we can, sometimes go find it ourselves and run some tests, and find out the empirical story for those 4 claims isn't too much of a happy one. So let me spend my remaining probably minute and a half my remaining time on the sort of what's next part of that, right? So if we were to employ, sort of goes the thought experiment that I want to talk about, would the 2017 rule, I guess I did do FTC/antitrust here, would it pass some sort of benefit cost standard based on what we know in the economics literature and empirical evidence? The easy part of this, I think, is what would perform better on a consumer welfare standard, a categorical ban, or say antitrust rules? Categorical ban, very difficult to justify. A categorical ban of just paid prioritization, much less sort of vertical restraints writ large. Very, very difficult based on an underlying empirical literature that says vertical restraints are generally good. But it begs the question, what do we do sort of in the exceptional cases, right? So antitrust is one type of case-by-case approach. And so that is one. There are others. So I want to spend a little bit of time sort of riding my comparative advantage until the wheels fall off, talking about what the antitrust approach means and does not mean from this perspective. Because so I'm an antitrust guy, always been an antitrust guy. I've worked at the FTC 4 times, from an economics intern to a commissioner. Antitrust is sort of what I do and know best. And when I forget who it was that made me enter the net neutrality policy debate, I believe it was Chairman Pai, for which he will forever owe me dinner. But the claims about what antitrust law does are a mess. Right? So I want to spend a little bit of time talking about those and maybe engaging with them. So the two major objections that I think one hears about this, even if you buy, we should do case by case, sort of buy Michael's premise, I think, in mind that what you really want to do here, if you're structuring legal rules and you care about consumer welfare, let's get the bad ones and allow the good ones. So we have lots of systems of law that are built that way. Antitrust is built that way. And so objection one is you could do case by case in the antitrust rules, but the truth of the matter is plaintiffs never win antitrust cases. And that's because the burden of proof is way too high. You know, the Supreme Court has made it impossible for agencies to win Section 2 cases. That is just not true on the numbers, much less private litigants winning these cases. And this is where the debate always gets interesting. One element of a monopolization claim in antitrust laws is that the plaintiff must show that the defendant has monopoly power. If you read the OIOs, both 2010 and 2015, that's exactly the claim, is I got to worry about when they've got monopoly power. And the antitrust laws say, okay, there are vertical contracts that are good. There are bad. Plaintiff must prove this one belongs to the bad set. Consumers were harmed. Maybe it's an output effect. Maybe it's a price effect. Maybe it's something else. But you've got to do that. And I think sort of a threshold policy question in net neutrality debate is, in a world where this stuff is sometimes good for consumers, even if you don't buy my proposition about mostly, and I do think that's what the literature says, it's sometimes good, sometimes bad, there's a world in which you allocate to the plaintiff a burden of showing this one belongs to the bad set, a feature or bug of the system. I think from an economic perspective, the idea that that burden of proof allocated to the plaintiff is a feature, not a bug, is pretty easy. Objection number two is, well, antitrust is really limited. It's a consumer welfare thing, and it's a thing economists talk about, but if you can't measure the anti-competitive effect we're talking about in dollars and sort of show it to somebody in a tangible form, then the antitrust laws don't touch it. There's sort of two things. There are different types of these claims. One is antitrust just does price and output, but if your real concern is in the long run, and Michael made this point about differences in between static and dynamic effects, in the long run you're going to get less innovation or something. The antitrust agents, this is in their guidelines. They wrote that. It's not even new. Right? It's been in there a while. There are cases they win. They are harder because you need to persuade an Article 3 judge, or if you're at the agency, you need to persuade some commissioners that that harm is likely. Right? But this is not sort of ruled out by law. Right? This is not a legal constraint upon bringing those types of claims. My casual empirical sense is what people really mean here is it's not a consumer welfare thing. I'll spot you the point that consumers are better off with paid prioritization, but they shouldn't like it. Right? There's some other harm that's going on. It's, loss of, freedom. I don't know. It's loss of something that's not captured in price, output, quality, innovation, or consumer welfare. That's this sort of other goal. For this, I don't think that there's anything an empirically minded economist can do. It's not an empirical claim, right? It's, detect the flavorless, tasteless, odorless harm, I think is something that, look, may be real, but it's a very dangerous thing to allow to guide policy that is dressed up and at least expressly purports to be about competition policy and improving consumer welfare. So if that does any successful antitrust law myth busting, then I'm a happy camper. But I will, in any event, stop there. Thank you.
Last but definitely not least is our partner in this project, Christopher Yu.
Well, thank you very much. I often make a joke at network neutrality events that anytime you have what purports to be a neutral criteria in speaking order always puts me at the end. And so there's always, what tells you is there is no such thing actually as a neutral principle. They all have predictable systemic effects because however you sort them, they always do. Even if it's always turn to the left or something that seems just completely arbitrary, it's just one of those things. But I do have to owe thanks to both, to starting off with Larry, and first to David Saperton, who's not here, for getting us started, as Larry so graciously pointed out, and to Tom. This has been a fun project, and it's been one that I think that we've really enjoyed and thought was important and timely. Sort of to the credit of everybody in the world, it's timely and important in ways that all of us never really anticipated at times. So I will, as with many people, talk somewhat about the paper, but go beyond it a little bit because the world has changed so much since then. And what's fascinating to me is what I think of this as the tale of two conferences, is we do have the issue now out in the review. And as Tom said so correctly, we were trying to figure out internet, sort of open internet order is here to stay. Still a lot of, people ask me what happens after network neutrality. The question was more network neutrality. What's reasonable network management? What are, what they used to call specialized services and now called non-biased services? You know, all these other questions that were going to come out we'd have to resolve, and which the FCC had punted down the road. Well, that took a very drastic left turn with the election, and now we have a proposal on the table that clearly would reclassify away from Title II, but is vanishingly thin on the details of what the statutory legal basis will be going forward, but more importantly, what the content is going to be. In fact, it's an open request for help on the part of the agency to figure out how to move forward. And so in a sense, I would think that the kind of basic research that's reflected in a publication like the Review Industrial Organization, regardless of whether the wrapper changes, is just as relevant in terms of the comments that are being made here today. So what struck me was, so I guess as Josh so correctly says, I'm probably going to talk more law than most, even though most of my work is very heavily IO tinged. But the real question is, what was the effect of the Title II reclassification? So we need to separate two things. There's two questions. One is, do we regulate an open internet, and so how? But the second is what the legal basis is. And to be clear, the current NPRM proposes moving away from one legal basis, but does not propose dropping all regulation altogether. It's trying to figure out what that's going to be. So talking first about the legal basis, we as a country were the only country in the world that did not automatically fold internet regulation into legacy telephone regulation. And in fact, in my opinion, that was one of the best decisions we ever made. Why? If you take a statute that was written in 1934 and amended over the years, that was set up for a different technological and a different economic context, and then apply those words to a new technology, how that application will happen is largely an accident. No one had that technology in mind when they wrote those words. We can apply words to new contexts, but it won't necessarily lead to a result that anyone would think is good. You actually have a different question is, okay, if we open up the whole reform question and anything can happen, is the risk of doing that bigger than keeping things the way they are? And that's always been the place where people have been, and we haven't moved. The other thing that's really striking about the existing legacy regulation is it violated the basic principle of technological neutrality. What we have is a regime that was written in 1934, and we stuck with a structure that defines regulation in terms of different technologies. And that made sense when all we had was phones and radio broadcasting, but in the modern convergent era, that makes no sense whatsoever. Title I turned away from all that. In 2015, we embraced it. And in fact, that's why there's a whole Title II and a separate Title III discussion in the Open Internet Order of 2015, and the whole reclassification went that direction. And in my opinion, I think that was a mistake. And that, in fact, I think that it walked away from what we think was, what I thought was a more productive discussion is, for this new phenomenon, what should the rules be, instead of taking the old rules and try to nip and tuck them into the world that we have. The other problem with the way the Title II debate has unfolded, it tends to focus on whether a certain practice is discriminatory. And even worse, discrimination has been defined in terms of its impact on other companies. Does this hurt edge providers? Does it hurt this edge provider over that edge provider? Any competition economist worth their salt will say that competition policy is to protect competition, not competitors. And that, in fact, defining things Title II defines things in terms of the impact it has on companies, that is a mistake. And in the process, the question of asking this is what Josh is getting at some of his remarks, and Michael, the question of whether it's discriminatory begs an important question about whether it's good for consumers. As Michael said properly, price discrimination is welfare ambiguous. Many times discrimination isn't bad, it can be good, The challenge we face is creating heuristics and rules that separate the two, but to say that something is discriminatory automatically means it's bad ignores all of modern industrial organization. And that is something that I've just never completely understood about this debate, but I think is encouraged by the way we frame things in terms of Title II. And so I think that putting on a sounder economic footing and a sounder policy basis requires us thinking about this in a different way. So the lens that I use in my paper to understand this is zero rating. And for those of you who don't know zero rating, the easiest way to summarize it in this country is a practice called a policy, a business offering by T-Mobile called binge on. My kids love binge on. Why? You can watch as much video as you want without it counting against your data cap. So why has this got a network neutrality issue? Effectively, it makes video cheaper than other applications. And people who oppose the practice, including, say that it's in fact favoring one application above all the others. Now, what's interesting is you probably know, both in the 2010 order and the 2015 order, the FCC punted on the issue both times. They issued an investigation last fall exploring whether they'd look into it, asking for information, under Chairman Wheeler, and Chairman Pai recently killed the practice going forward. And in fact, what you'll see is that we talk about zero rating as if it's a unitary practice, and it's potentially always, it's generally regarded as concerned as a bad practice. So what's fascinating to me is I actually did a study of every enforcement action ever brought in the entire world against the zero rating practice to see how this is played out, to see how actual policies implemented in the world, where the rubber hits the road. And what you discover is that zero rating serves radically different purposes depending on the market context it's deployed in. So the other prominent zero rating practice is run by Facebook. It's called Free Basics. It's done in developing countries, and they say here is a feature phone. And the thing we forget in this country, in the rest of the world, the internet is a 2G phenomenon. Forget 3G, 4G, or the 5G deployment. I mean, that's the way that they have to work things, and usually on recycled legacy phones that we've discarded and turned in and have been refurbished for the developing world market. So just so you know, they actually use it to attract new users. The data that Michelle pointed out is replicated in China, Brazil, India, every developing country they've looked at. The problem is people don't adopt because they don't see the relevance. And when you say get a connection, they don't get it. Get this, and you can talk to your kids, your grandchildren in some far-flung part of the world or the country, they get it. And the early evidence was 50% of those people trade up to a full data plan in 30 days. So they're thinking of it as a marketing product to get people on. In established market, it's actually ambiguous. It can be used by large incumbents of all kinds to enhance their market position. But what's interesting to me, it can actually be used by smaller players to differentiate their offerings and compete their way into the market. T-Mobile and binge on is a great example. It's actually based on Metro PCS, the technology they created, which T-Mobile acquired. Metro PCS deployed LTE on legacy 1G spectrum in some cities with 1.4 megahertz of spectrum. I mean, these people are heroes. They're making LTE work in areas, making areas more competitive where it couldn't be otherwise. The problem was, for limits of various reasons, they couldn't do it on all video. A large part, people had not written video players for the small little operating system they use called Brew. But more importantly, anyone who works in the video space says there's so many codecs out there, you can't support them all. And so the idea that you would support an arbitrary number of video, you can't do it. They were actually served with the first network neutrality complaint under the 2010 order for this practice. They had 3% national market share and were creating increasing competition in a way that was actually very beneficial. Now, the other thing I'll make a point, the way this works is it lowers the resolution of video from HD quality to standard definition. Why? When you're watching TV on a device this small, you don't care. That is not an application-neutral solution on the technical side. That is a specific video-only solution that solves actually what is in practice the big congestion problem on the internet, which is video. And so the funny thing is, the notion that everything has to be application neutral risks cutting us off to certain kinds of solutions which aren't, because the technologies just aren't. And it ignores why did Metro PCS supported YouTube initially? Why? They said that's what people want, not an arbitrary application or even an arbitrary number of video applications. And in some ways, going to what the people want or where the problem is a very natural thing to do with video. And that's, as we know, YouTube and Netflix by themselves cover about 55% of primetime traffic now, more than anything. This is a solution that makes a lot of sense. So what's fascinating to me is you have a practice that is susceptible to a competitive interpretation and an anti-competitive interpretation. What do we look for? We usually try to find practices, evidence ideally, and Josh has cited a bunch of studies that I often cite. There's been lit reviews that say these kinds of practices tend to be video welfare enhancing in terms of vertical restraints, and price discrimination is presumed to be generally video welfare enhancing. Setting that aside, we usually look for practices, proof of things that sort into the different kinds of behaviors. This conduct is only consistent with anti-competitive motives. This conduct is only consistent with pro-competitive motives. And we try to figure out how to figure it out, to sort them through. And what's missing from these rules is embrace of those kinds of devices. And in fact, the 2015 order openly considered whether they should put a market power screen on it, and they decided not to. And that, to me, is an inherent problem with where it's going to end up protecting competitors instead of consumers, because the number one thing you look at is that. The second is non-exclusivity, which is generally a characteristic of these. And third is if you're favoring if you're not favoring your proprietary services, but you're involving people bidding for a space on a platform, then it's a very, very different world. And if those things are generally free and open, you actually have a pretty attractive environment. So on the facts, I'll give you a couple examples. By and large, the zero rating enforcement actions were brought against number 3 and number 4 players in the market, not the leading players, who were trying to differentiate their products. So my two examples I think of, in Chile, which prides itself as being the first country to have a network neutrality regulation, enforced against Virgin Media, which was an MVNO, a mobile virtual network operator. It doesn't have its own facilities. It can't differentiate its network offerings. It can only differentiate its service offerings. Started zero rating WhatsApp. Why? Its competitor gave free text messaging, and it couldn't do it. They had 1.3% market share. They were hit with a network neutrality violation and were forced to stop. At the same time, they approved Wikipedia Zero. Why? Because they like Wikipedia. They think they're a good thing. And to me, that kind of arbitrariness is dangerous. In Slovenia, there were 4 players. The number 1, the number 2 player zero-rated the UEFA Champions League and the World Cup. The number 3 and the number 4 players zero-rated access to their own proprietary content. Now, I'll say one of the interesting things, anyone who does discrimination will tell you, discrimination is not charging different prices. It's charging different prices that don't reflect cost differentials. Conversely, charging the same price for things that cost different amounts is actually discriminatory. Access to your proprietary content does not require backhaul, does not require a lot of things. Arguably, this is a proper practice. Number 3 and number 4 players struck down by the Slovenian regulator. And so you see how this is playing out in practice. It tends to be going after the small guys who are trying to compete with the big guys by differentiating their services, much in the way that Michael and Josh and Michelle have been talking about. And it's an interesting way. We have to think about competition in this space happens in dimensions aside from price, and even aside from network quality, it actually happens in service offerings. And that's a very interesting set of problems. Okay, so what I would say is we've seen this movie before. And that, in fact, I think the path forward is clear. First is we have 2 very clear data points. The Supreme Court has said classifying broadband internet access as Title I is okay. And we'll never get clearer than that. Second, the DC Circuit has said, and it's potentially up for Supreme Court review, remains to be seen whether it will happen. Most observers think it will not. The DC Circuit says classifying as Title II, and Title III, that is, okay. Well, what we're going to say on this, well, I draw from this is that if that's both within the zone of reasonableness, either way is within what courts will uphold, any person in any side of this issue is vulnerable to a change of administration and their preferred policy is gone. So what is it? It's Congress's turn to speak. I have no illusions about the current Congress's likelihood of acting. On the other hand, the hope is that everyone on every side of this issue will try to find a common ground for a compromise. That would be ideal. Whether that actually happens depends a lot on politics that have nothing to do with communications policy. But what's fascinating to me is this actually mimics entirely what we saw in cable regulation. Cable deployed in the 1950s, and we saw nip and tuck ancillary jurisdiction went up and down to the Supreme Court multiple times trying to fit it into the legacy regime. until finally 30 years later, we passed the Cable Act of '84, followed by the subsequent amendments. This is the same thing we're going to have to do here. We can stretch and pull on the existing regulatory structure up to a point, but eventually we should recognize that this is a fundamentally different technology, and we should think through rules that make sense for it on its own sake. I'll stop there.
Thank you, Christopher. I'm going to ask one question and then throw it open to the audience, so you all should be thinking of good questions to ask. This really just keys off of what Josh was talking about. Basically, I think, if I understood him correctly, was that a cost-benefit analysis of the new FCC proposal is essentially a cost-benefit analysis of, or looking at the advantages and disadvantages of an antitrust approach. Maybe I'd like to ask the other members of the panel if they essentially agree with that, or they would modify that or embellish it in any way.
So one of the things that I admire greatly about the current NPRM is for the first time, it asks for comment on the cost-benefit analysis that agencies are required to do. And the idea that no one has physically put that up for comment prior to now for the FCC to me is, in fact, it never occurred to me, but when I saw it, it's like, why hasn't this been happening all along? If you want to get real input on it. And the plea I have is, when they cite empirical evidence, they tend to cite comments. I think there's an opportunity, regardless of where you are on the issues, to improve the quality of government in terms of clarity. And what struck me is they cite comments that a given company says something, and if you read the comments, there is no empirics behind them. That's not empirical evidence. And we should set up a norm within agencies that if they're going to say something is empirical evidence, they're going to cite a comment, there better be at least some semblance of empirical evidence behind it, because otherwise you're getting is business positions taken by companies instead of actual foundational evidence, and if that's what they're relying on, you'll never get a decent cost-benefit analysis.
Barbara?
Great presentations. I have a question particularly for Christopher. Your final bullet point, deja vu all over again, cable regulation, that would suggest you think there is a role for sector-specific regulation at the FCC for the ISP. So you want to talk about that?
So in a perfect world, you would blow up the entire title structure of the 1934 and start from scratch and make it depend on things that that's a really big risk, because everything gets in play. And the question is, that's a suggestion of why do we do Title VI in cable? Is because if anyone wants to get the answer, a major actor wants to get an answer to no in legislation, they can throw sand in the gear. And the proposal I heard that was the most interesting is people are talking about going back to something like the wax control from before around the 2010 time. A Democratic proposal, no amendments, up or down vote. And in terms of a mechanism to actually get something enacted, I think that's a more realistic model. In a perfect world, yeah, I'd open it all up. But there's too many ways. If you remember in 2007, the House passed a very modest bill. It got to the Senate. They tried to make it comprehensive reform. Died. That's the scenario I'm worried about.
And if you could say your name and identify yourself.
Rick Zimmerman with NCTA, the Internet and Television Association. So I can't usually say that I'm excited for the next issue of the Review of Industrial Organization, but I think this time I actually am. So Larry, one quick question. When exactly will this be available?
Well, it's still May. It's the June issue. Sometimes we come out a week or two in advance of the month. It's available. It's up on the internet.
Okay.
It is.
Okay, great.
It's electronically available, and they print a few hard copies, but it's available as we speak on the internet.
Larry's one of those people in Michelle's data who's on the wrong side of 65, so he doesn't know about
So, and then Tom, if I can throw out a substantive question also. So, Josh sort of gave the defense of antitrust. Hal Singer was mentioned a couple times. I'm sure many of you have seen his other writing that, antitrust in this instance is not good enough and it should be case by case. And I'm not going to explain his whole rationale, but Michael, and maybe this is mixing a metaphor or something here, Michael also indicated that in terms of price discrimination, that ultimately it comes down to a case by case analysis. So can you critique, Hal Singer's call for case by case versus antitrust if you've seen his blogs on this? Anyone?
Yes. Can I turn on the mic? It's different. All right. Yes, twice. Okay. So sure, and the relevant comparison is not case by case because they both are, right? So Hal's proposal, for those not familiar, is do case by case, keep it in the FCC, have a complaint-based system where the FCC decides case by case. The comparison is what is the criteria for liability. Antitrust has a 120-something-year-old evolution of precedent toward figuring out the criteria that help do exactly what Christopher was sort of aiming at, where the trick is here. Separate out the pro-competitive from the anti-competitive, and a body of law that is built up around that has evolved significantly over time for ways to incorporate economic method into these legal tests. You can get economists and lawyers to disagree on individual cases, but I think all observers of that framework think if you match up the relevant set of economics to the legal test, it asks the right questions, it does the right things. And what Hal's proposal is sort of stay out of antitrust, keep it inside the FCC, and the test would essentially be, and to be fair to Hal falls into on my sort of antitrust fallacies into the second category, thinks that the real harm here is long-term innovation stuff, and antitrust doesn't capture it. That's wrong as a matter of law, and I think Hal means something, again, it's what he's proposing is much better than the status quo, so I don't want to be too critical. But his objection is, sure, antitrust says it gets to innovation, but does it really? Again, I think it's a little bit the wrong question. Does it better than the FCC would, right? Sort of compared to what? I think that the track record and the framework in antitrust is superior in just about every possible way. Plus, it doesn't require reinventing the wheel, which is also good.
And you're completely unbiased.
Well, but
Yeah.
you want to address
yeah.
more specifically the question of our experience with sector-specific types of...
Yeah, so totally biased, but biased because one has a track record and one doesn't, right? I don't know, that's a type of bias I'll take all day. Yeah,
Can I just say something, having been in both justice and the FCC, trying to parrot what you said, I would much rather have the thing go through general antitrust. The claim for the FCC always is, well, okay, they have the specialized expertise and you develop it over and over. Certainly in its role as serving as a plaintiff, though, the DOJ or the FTC can develop that expertise, and in fact they have. So I think the only place where you're talking about making a difference with expertise is potentially with judges, but there I don't think the history has been very good. Personally, I think we're much better off having to have the agency, in its role as a plaintiff acting for the public, have to go in front of a neutral judge that's outside of the agency and has to say, okay, this is the legal standard, here are the facts. I mean, I think there really is no question. There have been legal decisions that are pretty screwy, but I would say there's really at least no doubt in my mind that overall the quality of the arguments made and the cases made and stuff when it goes through the courts, as opposed to, and you look a lot of different sector-specific regulatory regimes, look what happens internally versus what happens when you have to go through the courts. It's just way better through the courts. I mean, the whole thing of the agencies and the industry, and you all get to know each other, I think that generally that's, apologies to everybody in the room, but I think generally that's pretty corrosive. And it's a lot better when you're trying to come up with rules that have to apply in general, because it forces you to think about principles as opposed to, oh yeah, I just met with those guys last week and here's what they told me.
Bob,
Oh, good.
Shall-
You want to say it? Go ahead.
So I mainly wanted to agree with Josh that I have a biased opinion and I agree with you. The way economists are used is up until this date very random and haphazard. I do not trust in the current setup that an internal system, and I think this is a good point that Michael has, we've seen that be corrupted by political pressures, and so they've been caught too many times with their hands in the cookie jar.
Yep, Bob.
Is this working?
Sometimes you have to press it a few times.
Well, I'm not disagreeing with our antitrust authorities here, but I think in this circumstance, it's both very difficult to do cost-benefit analysis and also in the court of law to explain the potential benefits or costs of any new practice, which is all going to be prospective. I mean, it's very hard to muster empirical evidence on a prospective policy of T-Mobile or of Verizon or of someone else. Most of our antitrust precedents deal with long-standing practices by Alcoa, even Microsoft. And this is a fast-changing world in which it's very hard to assemble empirical data in support of one approach or another, even in a court of law.
Just one thing on that, though, but I think that in a lot of ways is a virtue of the antitrust approach, because if you're to go in and try to stop the practice in advance before it's done anything, there is a very high standard. But I think that should be the standard, because it's going to be extremely unlikely that, like say this stuff with T-Mobile, that it's going to do irreparable damage to the market that you can't undo. So I think this, wait and see, and then if there's a problem, come back at it, generally is a better approach.
Well, I agree. There's type 1 and type 2 error here, and we got to worry about the type 2 error.
And actually, you have chief economists from the FTC agreeing with you. It's a matter of inference of where you put the burden of proof. If you want a world in which innovation is going to occur, the default answer should be yes until you prove harm instead of no until you can prove benefit, and that's obvious. So at the risk of actually being the person who actually might be defending the FCC, which is a role in which I'm traditionally not placed, what I would say is there's one problem here, which is Trinco, which is we have a question on the Supreme Court decision that limits the scope of antitrust in Section 1 here. And how that's going to play out will depend on somewhat on the regulatory regime. On the other hand, specifically talking about Halsinger's proposal, his model is not antitrust. I would see case by case in the FCC, you could defend it if it was based on antitrust. He wants to base it on the program access rules from cable, which I really don't want to get into all the details, but let's just say is controversial. And I don't think anyone is happy with how well those are working out right now.
I'm Mike Nelson. I work for Cloudflare, which is a cloud-based security service. And our CEO came out very strongly against the open internet order 2 years ago. But I wanted to dive a little deeper into what Chris said in two different ways. First, you were very pessimistic about the Congress actually doing the right thing and giving us a stable solution. I'd like to ask the other four of you what percentage you would give on the Congress actually acting in the next 2 or 3 years. And the second thing I wanted to do is go into the international side, which you did, and ask all of you if any other country you know of has actually addressed net neutrality properly, or if you have a candidate for the country that has done it worst. So it's a little complicated, but we work globally and we're seeing some very strange things being done in the name of net neutrality in Korea, in India. And so I'd like to know if you've seen any models we can point to as good or any other models we need to be watching out for. Michelle?
I think I actually want to learn from you. As many good Americans, I tend to look at the U.S. more than I do anywhere else, so I can't tell you that I have technical knowledge. But I'd be very interested to see what has been done, what
join Bob in ducking the question about the international. I guess I don't see Congress doing it. I mean, I know what Chris is, saying, oh, is there some reason to be optimistic about compromise? It just seems so much of it, so it's either we want to regulate or not. It's hard to see what the compromise would be. I do think it's too bad because, while in general, I am very much one for relying on antitrust approach. I mean, the competition policy. But I do agree, though, that the technologies we're talking about do raise broader issues. I was made light of the issues about free speech, but when I'm talking about my proposal for advertising neutrality, but there clearly are important speech issues, and I think that is worth society giving some serious thought to what we need to do with bias providers. Although, frankly, I think on that, the bias providers, if I were they, would try to get treatment as common carriers for speech purposes only, which is to say, just keep us out of it, because that's really not a good place that we want to be commercially, and we would rather actually have it declared, like the phone companies, that it's not our fault what goes over our lines. But my guess is a lot of them would be happy in return for being made sure that they weren't liable for it, that they would also give up the right to cut things off. But also, though, if we were going to take on this issue, then you really got to start thinking about not just the, let's think of it sort of hardware and software, but it's not just about the bias providers. I mean, if you think about in this country, threats to free speech and the dissemination of ideas, clearly Facebook and Google are way more important than Comcast and AT&T in terms of the things they could do. And so if we are going to have a serious debate about it, which I don't think we will, I would include the internet, the service providers, the big edge providers as well.
I'm going to come up with a different way to dodge the question. I spend more time with antitrust regulators overseas than I do with sector-specific regulators. I do know, I think the happiest news one could give is that there certainly are jurisdictions in which there is a push from the antitrust regulator to take a greater chunk of what is going on with respect to net neutrality. How successful they will be, I don't know. This is a lot of places, and the European antitrust regulators want to get everything. But lots of places around the world, I think those types of attempts are happening. How they'll be resolved, I don't know any more than I know how they'll be resolved here. But that, at least, I think, is to the extent that those international antitrust regulators are sort of wed to the generally accepted antitrust framework. That's probably more good news than bad. I think the probability of a legislative solution is 0, and only knowing math is stopping me from saying negative.
So I've already answered the first one. Internationally, hands down, the worst country in the world is India. There are 7 billion people in the world, 3.5 billion not on. 1 billion of them are in India. They have 1.3 billion cell phone users, only 300,000 internet users. These are people who have power, have connectivity, have everything. They're not on. So and they've banned network neutrality categorically and wiped out free basics. A bunch of people who are getting on now, it's like, I'm sorry, you're getting this for free. This is bad for you. If you want a good example, there's a bunch of countries that looked at it and chose not to. Japan immediately comes to mind. But if I were to pick one country right now, UK. Interesting doctoral thesis written by Alyssa Cooper. I don't know if you know her. She is the head of the IETF now, works for Cisco, and among other things is Mark Cooper's daughter, for those of us who know this town. She studied, and in fact, that there are 10 ISPs, and if you know how things work with OpenReach, this is largely DSL wholesale resold service. One of them is unmanaged, 9 of them are managed. And that's an interesting model to me, which is there's an optimal number of, so we say competition should provide an unmanaged service for people who want them. They do. There's an optimal number of them. It's not 100%. You wouldn't want 10 unmanaged services. That's redundant. They actually have 1. Whether the optimal number is 1 or not, I leave to you, but the idea that they've got a world in which people are doing different things. The best example is PlusNet. PlusNet was recently acquired by BT, but it's a small provider, uses DPI to segregate traffic into 9 prioritization classes. Class number 1, World of Warcraft, online gaming, on a DSL platform. Highest customer satisfaction rates in all of England. Why? They're taking a DSL pipe, providing highly video interactive, and they're doing it by targeting a niche strategy as a small player to make in the kinds of things that Michelle and Michael are talking about, targeting a product instead of trying to bring everything to everybody and making it go as a very small player. I have old writing on this going back to Chamberlain. The beautiful thing about product differentiation, it allows stable equilibrium on the declining portion of the average cost curve and solves the scale problems in ways by allowing differentiation.
Hey, how's it going? Ryan Wallach with Comcast Corporation. I have one clarification that leads into a question, and I think Dr. Crandall's use of paid prioritization in referring to the Netflix Comcast agreement is a bit of a misnomer. The FCC in the 2015 order made clear that paid prioritization in that context was technical prioritization, and Comcast doesn't prioritize any bits of the internet traffic. But I do think it leads into what is this issue of prioritization? And Dr. Katz pointed out a number of issues, a number of means of prioritizing, often completely within the control of the edge provider. And my question really is, how does that play into an analysis of cost benefit? Is the uncertainty that's created by what you can do as an ISP or as an edge provider or as maybe a CDN provider, and interconnection, things like that, does that factor into an analysis on cost benefits, or is the evidence and costs we're looking at in that analysis more realistic or more determinative?
Well, I think there's a difference between whether it will or it should. I mean, in terms of the look, the costs created by uncertainty, I didn't expect that they are real costs, but they're also costs that it's easy to overlook if you want to. But I think they should be in. But let me say something else about cost-benefit analysis. Well, I certainly think it's right that we only want to have regulation where the benefits are bigger than the cost. We shouldn't, I think, pin too much of our hopes, though, on doing it. I mean, it's one thing to do cost-benefit analysis where you're deciding is we're going to build a dam on this river or not. And by the way, if you build the dam, there's obviously the right way to do it if you're going to do it. The question is, do you build the dam? That's really different than asking the question, what happens when I have a policy that has, say, 5,000 different dimensions to it and sub-decisions and things? So what is it you do? Are you saying, well, I mean, first off, I don't know what cost-benefit analysis you could do based on the current NPRM because there's not a specific proposal in there, right? So I guess you could, so if you said, well, we're going to trash the 2015 thing entirely and just rely on antitrust and all the following rules are gone, then you could do a cost-benefit analysis. But I'm not sure what the analysis is of now. And the problem is, even if you do have a specific proposal, right, then the question is, do you say, well, we're going to evaluate these regulations versus just having antitrust? Or should you say, well, instead of these regulations, here's another set of regulations that are even better? So, yes, I'm in favor of trying to have rational regulation, but it is a really hard problem when you're talking about all the different dimensions we have, the way we're doing it. And I do worry that sort of treating it as sort of project analysis may be creating false hopes.
So Ryan, I think your question actually gets at an ambiguity, which I think Michael's talk pointed out, which is the choice between prioritization, paying for prioritization, direct interconnection, building CDNs should be endogenous. We treat them as if they're separate things and apply different sets of rules when in fact so Netflix had an interconnection arrangement through another provider that worked just fine. And it tried to buy a cheaper one on a promise that the peering relationship that Cogent had would hold, assuming that on a barter relationship where I was talking about a mutual exchange of even traffic, if you take something that's 1/3 of the internet and add it to one side, you expect the barter relationship to hold. Now, that's just not plausible, but that's what they were doing. Now, they're at the same time doing their CDN on other places where it's not necessary, and they're making their own choices endogenously. And the way we need to think about it is not the point of when they decided to make the interconnection agreement. The decision point is when they switched to Cogent. And if we look at their options and the thing, and they can also reroute through a number, I think it's 50 or plus peering arrangements in the Comcast 8,000 transit arrangements, all paying different amounts. There's a wealth of options. We need to understand the way that those work. What's fascinating to me is, we have to look at cost-benefit analysis. This is a great example. Dave Clark happened to be tracking the connection between Comcast and Netflix at the time of the changeover. And by the way, I clarify, Michael, you're right. It's been there, but prioritization was in IPv4, and it's been since the very beginning. It's always been there, not just since IPv6. What's interesting is we found evidence that better service, lower cost with direct interconnection. Cut out the middleman, get a real service level agreement. You can actually guarantee and measure traffic. From a CBA standpoint, this seems to be clearly better. And it's a pretty easy case that you can draw. And in the days leading up to the direct interconnection agreement, there were 3 transit connections between Netflix and Comcast. But week by week, one was completely congested, the other 2 were open. Then another one was completely congested, the other 2 were open. It was fairly clear that this wasn't something the network was doing. The data source, that is Netflix, was moving the traffic around. Or some upstream network is moving the traffic around to make it go in different ways. So what we start to understand is the way things work in terms of congestion is not just a function of what any one actor does. They're all in a position to try to influence that. And we actually have great documentation out of that, both out of that project and out of Nick Feamster's project out of Princeton.
We're actually a little over our time, but if there's one last question, I'll take it. But if not, please join me in thanking the panel.